Hello, everybody, and welcome to History/Law Bite number 261, dated May 24th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled President Truman's Supreme Court Appointments. Harry S. Truman served as the 33rd President of the United States of America from April 12th, 1945 to January 20th, 1953. During his near 8 years in the presidency, Truman, a Democrat, made 4 appointments to the Supreme Court of the United States. In doing so, he replaced the following jurists. First, Justice Owen Roberts in 1945. Roberts had been appointed to the court in 1930 by President Herbert Hoover. Next, he replaced Chief Justice Harlan Fiske Stone. Stone had originally been appointed to the court in 1925 by President Calvin Coolidge as an Associate Justice. He, however, had been elevated to the position of Chief Justice in 1941 by President Franklin D. Roosevelt. Stone died in April of 1946. Next, Truman replaced Justice Frank Murphy in 1949. Murphy had been appointed to the court in 1940 by President Franklin D. Roosevelt and had served for 9 years. He passed away in July of 1949. And last but not least, also in 1949, Truman replaced Justice Wiley Rutledge. Rutledge had also been appointed to the court by President Franklin D. Roosevelt. He had been named to that body in 1943 and served until his death in September of 1949. Okay? So those are the 4 Supreme Court justices that President Truman would replace. Now let's talk about the guys he chose to replace them. With the very first vacancy occurring with the retirement of Justice Owen Roberts in 1945, President Truman nominated U.S. Senator Harold Burton of the state of Ohio. One thing, before I go any further, just want to add, one thing I really like about doing these videos about Supreme Court appointments from presidents of old, such as Truman and others, is that the process was so much simpler back then, folks. You know, Supreme Court nominations were not the political shitstorms that they are now. You know, I mean, you had occasional ones, but they were the exception, not the norm, like it is now. All right. Today, it's hard to have a Supreme Court nomination, you know, without it devolving into a political nightmare. Okay. And you didn't really have this that often back then. So, but anyway, just wanted to make that point out. So he nominated U.S. Senator Harold Burton from the state of Ohio to fill that vacancy left by Justice Owen Roberts. Truman, when he was a U.S. Senator from Missouri, had served in the Senate with Senator Burton, and the two had developed a very close friendship, all right? And, you know, just to emphasize the point I just made about how simple nominations were, Senator Burton was nominated to the Supreme Court on the 19th of September, 1945. Guess when he was confirmed? The 19th of September, 1945. All right, without any debate whatsoever. All right, and his confirmation was virtually without any opposition whatsoever. All right, and he took his place as an Associate Justice of the Supreme Court. All right, over the next 13 years, Justice Burton would prove to be, you know, a civil rights liberal, criminal law conservative, and like most of Truman's, if not all of Truman's appointments to the court, very deferential to government power when it came to restricting, perhaps in appropriate circumstances, civil liberties, as well as fighting communism at home and abroad. All right. Towards the latter part of his tenure, he developed Parkinson's disease and was soon advised by his doctors that it was time for him to leave the court, if he wanted his health to not get any worse. And as such, he submitted his resignation to President Eisenhower in October of 1958 and would be succeeded by Justice Potter Stewart. All right. He would die on October 28th, 1964. All right. So that was Truman's first appointment, Justice Harold Burton, who served from 1945 to 1958. His next appointment came, like I said, with the death of Chief Justice Harlan Fiske Stone in April of 1946. You may not be aware, but at this time, the Supreme Court was a very, very, very divided body. You think it's divided now. It was really divided back then. The court was basically split into two factions, one led by Justice Felix Frankfurter, the judicial restraint faction, and the other led by Justice Hugo Black, the activist faction. All right. And, Truman, wanting to bring these two warring factions together, decided to nominate a man whom he felt was a peacemaker and able to bring together normally warring parties. All right. So he chose, his very good friend and, longtime government servant, Frederick Moore Vinson, all right, who at the time was serving as Truman's Treasury Secretary. Vinson had also previously served as U.S. federal judge and also in the administration of Franklin D. Roosevelt and as a U.S. congressman. So Vinson certainly had prior experience in, all three branches of government. All right. He was anything but an unqualified guy. He had executive, legislative, and judicial experience. Very well-rounded man. Arguably one of the most well-rounded individuals to be appointed as Chief Justice, having served in all three branches. All right. And Vinson was thus nominated on June the 6th, 1946 to replace Chief Justice Stone, all right, in the court's center chair. There was little, if any, opposition to Vinson's nomination. He was very well known in Washington circles and certainly had the respect and confidence of most politicians of the era, and was confirmed on June 20th, 1946. Like the other Truman appointees, Vinson proved to be a very consistent vote in favor of civil rights, for African Americans and others. He also proved to be a traditional criminal law conservative and deferential to the federal government's ability to fight, suspected anti-American activities, communism, Vinson also took a very, very expansive view of presidential power, okay, as evidenced in his dissent in the Youngstown Sheet and Tube Co. versus Sawyer case in 1952. All right. Vinson was a classic jurist of the era, a classic Truman appointee. And, like I said, he was very close friends with President Truman and, was loath to deny his good friend any power. All right. Which is why his dissent in the Steele seizure case was so passionate indeed. He was the Chief Justice. At the time, the Brown versus Board of Education case was initially argued before the U.S. Supreme Court. However, the court was so internally divided when the case was initially argued, however, that a re-argument was ordered. But Chief Justice Vinson died before the case could be re-argued. And he would be succeeded by Chief Justice Earl Warren. All right. So Vinson passed away on September 8th, 1953, after 7 years of distinguished service on the U.S. Supreme Court. All right. And to date, he is the last successful Chief Justice nominee to be appointed by a Democratic president. That's right. Not since Frederick Vinson in 1946 has a Democrat successfully nominated anyone to be Chief Justice of the United States. All right? So that's a record he may hold for a good while. All right? So that's Truman's second appointment, Chief Justice Frederick Vinson, who served from 1946 until his death in 1953. All right? So Truman's third appointment was Justice Tom C. Clarke. All right? Now, his third appointment came with the death of Justice Frank Murphy in July of 1949. Sorry for the spoiler, by the way. So to fulfill this vacancy, Truman chose his own Attorney General, Tom C. Clarke. A very friendly and outspoken Texan, and to date the last Texan to serve on the Supreme Court. Clarke was indeed a qualified man, having served as Truman's Attorney General and having practiced law in Texas for many years. However, when Clarke was nominated on August 2nd, 1949, there was widespread opposition to his nomination from both Democrats and Republicans. Lots of people viewed Clarke as wholeheartedly unqualified to sit on the Supreme Court. Indeed, they viewed him as nothing more than a crony of President Truman, all right? Viewing his lack of judicial experience and other things as potentially disqualifying factors. But I'd like to add that Clarke wasn't hardly the first person who had no prior judicial experience. I mean, look at Senator Burton, who was Truman's first nominee. No judicial experience. So I don't know where that's coming from. But as a matter of fact, the vast majority of our Supreme Court justices being appointed to the court was their first judicial experience ever. So this lack of judicial experience is nonsense. That is not a prerequisite for the court, nor is it a guarantor that you'll be effective as a justice just because you had judicial experience before, because I've heard it from numerous justices that no prior service prepares you for the Supreme Court. So anyway, back to the subject at hand. In spite of the opposition, Clarke would be confirmed on August the 18th, 1949 by a 73-8 vote. During his 18 years on the Supreme Court of the United States, Clarke arguably was the most influential and most successful of the four Truman appointees. All right? Clarke would definitely grow on the court in his constitutional thinking. All right? Unlike the other Truman appointees who only served a few years, Clarke was on the court for almost 2 decades. All right? And that's certainly a significant amount of time to have an influence on constitutional law. All right? During his time on the court, like I said, like most of the other Truman appointees, Clarke was generally a consistent law and order conservative, but, an unwavering civil rights liberal. And when it came to civil liberties, it truly depended on the issue, all right? But like I said, Clarke grew on the bench, and, he definitely left his imprint on constitutional law, all right? Some of his most famous opinions were Mapp versus Ohio in 1961, which extended the exclusionary rule of the Fourth Amendment, based on the Fourth Amendment, rather, to the states, as it had previously only been applicable to the federal government and its courts, and not the state governments and their courts, all right? Mapp extended the rule to the states and their courts, all right? Excluding unlawfully obtained evidence, all right? Other famous opinions by Clarke were Heart of Atlanta, a Motel versus the U.S., and Katzenbach versus McClung, both in 1964. And both of those decisions upheld, the provisions of the Civil Rights Act of 1964. Now, it was undoubtedly a strategic move by Chief Justice Warren to assign those two opinions, Heart of Atlanta Motel and Katzenbach versus McClung, to Clarke. being that he was the only Southerner on the court in 1964. And to lessen perhaps the resistance to the Civil Rights Act of 1964, Warren perhaps logically presumed that to have the Civil Rights Act upheld and proclaimed in its terms by one of their own, Tom Clarke, who was a Texan, like I said, it might be easier for them to digest. And that much is debatable, all right? But it was certainly a smart move nonetheless on the part of Warren, all right? Because, if he had written the opinion or given it to Brennan or Douglas, it would have just been seen as a super liberal, northern-dominated court imposing its views on social equality on the South. But you've got these opinions being written and delivered by a Southerner, a Texan at that. So it's not like we command because we're from the mighty North. No, you've got one of your own from Texas, delivering in his soft Southern drawl, upholding the Civil Rights Act of 1964. All right, and therefore, it was theoretically supposed to be easier to take. All right, and how easy it was to take for them, you'd have to ask. But like I said, it was a smart move on the part of Warren. So Clarke, again, served with distinction until his retirement in June of 1967, when he stepped down due to his son, Ramsey Clarke, being appointed Attorney General by President Lyndon Johnson. All right, Clarke would be succeeded on the court by Thurgood Marshall, the court's very first African-American justice from my hometown of Baltimore. All right. Now, it is quite clear and obvious that President Johnson effectively pushed Clarke off the bench by appointing his son to be Attorney General, and Clarke would, of course, not stand in the way of his son's political career, all right, and thus stepped down, allowing Johnson to make history once again with appointing the court's first African-American justice, Thurgood Marshall, all right. Clarke passed away in 1977, all right. So that brings us, so that's his third appointment, Justice Tom Clarke, who served from 1949 to 1967. All right. And last but not least, we have his fourth appointment to the court, which came from the death of Justice Wiley Rutledge in September of 1949. All right. Now, to fill this vacancy, President Truman selected U.S. Court of Appeals Judge Sherman Minton, who was serving on the 7th Circuit, all right? Like Justice Burton, all right, Minton had also previously served in the Senate with Truman, all right? Like Truman, of course, was from Missouri, and Sherman Minton represented the state of Indiana, all right? The two had become very close and viewed him as a very more than qualified nominee to the Supreme Court of the United States, all right? He was nominated on September 15th, 1949. And, with relatively there was some opposition to him, very minimal though. He would be confirmed on October 4th, 1949 by a 48-16 vote, largely a party line vote. Remembering how, in the Senate, Minton had been somewhat of a divisive figure, and thus he was not popular with everybody. But so there was opposition to him, but it wasn't enough to derail him. All right, it's a 48-16 vote. So you got a lot of people obviously not voting there. All right. So on the court, Minton, arguably was, in my opinion, one of Truman's most conservative appointments. When he was a senator, he was a very passionate New Deal liberal. However, once he got on the court, he was as far right as you could go. But when he needed to be liberal, he was, and especially in the areas of civil rights. All right, he was an unwavering defender of civil rights of African Americans while he was on the court. And as like all the other Truman appointees, he was very, very conservative when it came to cases involving criminal procedure and assertions of civil liberties violations. He strongly supported federal power to deal with communism, both at home and abroad. You notice this common theme among the four Truman appointees? Like I said, all of them pretty much were of the same mold in that regard. They were, emphatically supportive of, the government's goals at the time, which was dealing with the spread of communism at home and abroad. All right. So they strongly supported that. And, like traditional jurists of the 1940s and 50s, they didn't exactly have a bleeding heart for the alleged violations of defendants' rights, in criminal procedure. All right. They strongly supported the power of the state to prosecute the bad guys without many limitations. All right. So, like Burton, however, Minton soon afflicted with poor health while serving on the court, and he was soon advised that for the sake of his health, he too ought to retire. And after 7 years and 3 days of service, Minton submitted his resignation to President Eisenhower in October of 1956. He would be succeeded on the court by the legendary William J. Brennan Jr. All right, we all know that name. All right, Justice Minton lived until April of 1965. All right, so those are President Truman's 4 appointments, and I'll go down the list once again for date and clarity purposes. His first appointment was Justice Harold Burton, who served from 1945 to 1958. His second appointment was Chief Justice Frederick Vinson, all right, who served from 1946 until 1953. His third appointment was Justice Tom C. Clarke, who served from 1949 until 1967, the longest serving of the 4 Truman appointees. And his last appointment, his fourth, was Justice Sherman Minton, who served from 1949 until 1956. Any questions or controversies, leave them down below and I'll be happy to answer them. If you like this video and learned a thing or two from it, drop me a like, please. I would greatly appreciate it. And if you've not subscribed to my YouTube channel, I humbly invite you to do so now. Your approbation of my work means more than you will ever know. All right, take care, stay safe out there. Thanks so much for listening to this History Bite, and I'll talk to you at the next one. Peace.